Welcome back, for some of you that is at least, and for some of you welcome for the first time. This is RFA 6130, Introduction to Food Law. My name is Dr. Mark Sanchez. For some of you, we are continuing right off from the previous 6 weeks in 6110 into 6130, so you're familiar with me and my approach. And for some of you, this is the first time you're taking a course with me, and welcome aboard. We are going to have a great 6 weeks together. A lot of information, as always, packed into a very short time frame. So buckle your seatbelts. So we're going to cover hopefully some topics that are familiar in a new way, as well as some new topics that maybe you haven't dived into before. So for this lecture, it's going to be a little bit different than the typical one, where I'm going to break it into 3 parts, and you can take it and pause it and go through if you need, rather than one topic for the entire lecture. And I'm doing this in part because I want to introduce my expectations for this course, and as I mentioned for you, that some of you coming from 6110, these expectations are different. We are not in 6110, we are in 6130. We have a more focused subject, and my expectations are very different. So I want to make sure that we're looking at that in particular for the written assignments. Now, for the written assignments, what I'm expecting you to do is to follow this path, and I think you may have seen it in other courses, is to use what's called the IRAC method, IRAC. Basically, I'm treating this as a mini law course. This is Introduction to Food Law. This is how a lawyer would approach these issues, and this is how I want you to approach these issues. One of the main reasons I want you to do this is some of these topics are going to be so familiar to you, you're going to just say, yeah, blah, I got it, skip, do a really fast analysis, and not hit the issues that I'm wanting you to think about. And so by using this method, we're slowing down, we're taking it bite by bite to see what is the point here, what is the statutory authority, the CFR authority, how does that apply in particular, and what kind of conclusion can I reach. So this method is really going to slow you down, and the aim of the game is quality writing, but also very analytical, thoughtful writing, and that's what I'm looking for through this method. Citations are going to be really important. In previous course that you had with me, I didn't really care about citations because we didn't get into them. We were talking broadly about the regulatory life cycle, and that doesn't necessarily have citations or relevant pieces that we were directly talking about. Here, we're digging into the statute, we're digging into the CFR. I need to know where you're looking and that you're looking in the right places in some instances in the written assignments. So this is our model for written assignments. I want it in the discussion boards, I want it in the substantive written assignments. So everywhere we're going, this is how we're going to be writing. I'm covering the citations in a particular format as well. Not only that am I expecting you to do citations, but that I'm expecting you to do them as a law student or a lawyer would do them using the Blue Book method. The Blue Book you can find, of course, in purchase. You're not going to probably need it for other courses. So what I'd recommend doing is you can find, like I did here with these images, versions online. It doesn't matter to me that you have the latest version. It's one of those books that's constantly changing. In general, you see a case citation or a statute citation or a CFR citation. That really isn't going to change between models. So if you find something online and it looks like it's maybe a 2015 or a 2014 version, that's okay. You're going to pretty much get the same format here. But as long as you're following pretty close to this Blue Book format, that's what I'm looking for. As I mentioned, CFR citations, we're going to look at those. Final rules, we may talk a little bit about final or proposed rules. We're not going to touch too much on the Food Safety Modernization Act, so that should be minimized a little bit. But if you do run into one of the final rules or a proposed rule, maybe something like the fact panels or something else that's coming out, maybe one of the definitions of a term, you may want to cite to a final or proposed rule. The CFR will be far more common for you. Guidance documents are a little bit of an oddball because they're not a CFR or a statute or a legal opinion. They're a guidance document from the agency. But here's how I want you to cite those, and you can reference the slides. All of the slides will be available as a PDF. So when we're talking about grading the written assignments, there's some expectations that I'm looking for in terms of how I'm measuring the quality of your work. And what I'm doing in these assignments, in the substantive assignments in particular, is to put you in the role of responding to the FDA. And so we want that professional voice. We want that concise writing. We want a very thoughtful analysis that is getting to the basics, getting to the definitions, getting to the right CFR or the right statutory and applying that in the right way. So this is going to be in some instances writing to the FDA after an inspection, writing to the FDA in different scenarios. So remember our audience and remember concise, professional, analytical writing. And also, one of the hard parts about teaching this course is we have to put artificial constraints on what we're talking about. We only have 6 weeks. It's not a lot of time. And there's a ton of topics. And you work in industry. Almost every student I meet works in industry. And so you know something about your job responsibility or something that you've heard maybe from a State Department of Agriculture or from the USDA or from the FDA or something else. That's all great information, and I don't want to discourage you from learning or using that in the discussion boards. But in our substantive written assignments, I really want us to just go into the artificial constraints, keep it to the material covered, keep it to the scope that we're talking about. That's going to really help you meet the page requirements. It's going to help you be clarified and concise in your writing. So that's enough about expectations. We're going to shift to the second part of the lecture. There's going to be 2 substantive parts in addition to that expectations piece that I just finished. So we're going to touch on the basics of the U.S. legal system. A lot of you know about this, but it's good to come back to the basics. And then we're going to touch on to our primary week 1 topic, which is looking at the FDA, one of our primary food agencies. And it's important to look at the U.S. legal system, if for nothing else, just a refresher of civics, but also really one of the keys to pull from this is the hierarchy of law. How we look at various pieces of law. Do we give the CFR more weight, the guidance document more weight, the statute, and so forth? And so in our basic framework, you know this, we have the U.S. Constitution, we have the Bill of Rights. Bill of Rights does come into play when we're talking about 6130. We're talking about warrantless inspections of facilities when we're talking about the FDA and that ability for the FDA to conduct those inspections as a government agency, search and seizure type things, Bill of Rights. Free speech is a huge thing I hear from clients when the FDA tries changing their labels or telling them that they are making claims they shouldn't be making. Separation of the branches, all of that sort of thing we know about, the judiciary, the legislative branch, and the executive branch. Some of that playing more importance in the current situation where we have a maybe more unpredictable situation with what can Congress do, what can the executive branch do in terms of changing the law. So when we're talking about statutes, the statute is essentially coming after the Constitution. The Constitution sets the boundaries for what can be legislated. So Congress can do certain things, and that statute is their voice for doing those things. So they have to be consistent with the Constitution. They're subordinate to the Constitution. And so, for example, you can't have legislation that erodes the Bill of Rights because the Bill of Rights is over the statute. So that's one of the main constraints that we see. You'll see how they're annotated, USC or USCA. Typically, when we're talking about food, we're talking about 21 USC. You may see some of the USDA pieces be cited differently. When we do have that happen, variation in how the statute is cited, I will make sure to note that. But in large part, 21 USC, we may see a little of 7 USC or 9 USC. And as we'll talk about, that way we annotate or reference continues through. So we'll see that same 21 number when we talk about the Code of Federal Regulations. When we talk about regulations, we're going one more rung down. So we've gone from the Constitution down to the statute, and then the statute down to the regulations. And each way we're interpreting. So the statute is interpreting what it can do based on the Constitution. The regulation is interpreting what can be done based on the statute. So a lot of times when we get a statute, we've seen this with the Food Safety Modernization Act, you essentially are giving the agency discretion. You need to do X. And it doesn't tell you how to do X or what X should be done in what way or what method or any of that. And so we see that the FDA then promulgates rules. We have the 7 core rules of FSMA. Those weren't in the statute, but were required from the statute. And so that's how it sort of works. It's an enabling statute, and this is the operative rule. And it really works for industry, because if we had to just comply with the statute, it would be very confusing, very subjective. But when we talk about a CFR section, a Code of Federal Regulation rule or regulation, same thing, we have something that's more operative. It has to be consistent with the Constitution, has to be consistent with the statute, and there's another piece that must comply with the Administrative Procedures Acts. The APA is sort of the default for all executive agencies like the FDA, like the USDA, that they have to follow a certain requirements to make sure that the rulemaking process and the regulations are fair, maybe under due process or other things. So a lot of times, for example, we will see notice and comment prior to rulemaking. There's an opportunity to engage in the rulemaking prior to it happening. As I mentioned, the reference will continue with the 21 number. And again, we'll see some of that change with the USDA, but we'll note that where it does change. So then we have cases, and we are going to be reading cases, and you'll see that already in week 1. Cases are interpreting all of those things that we just talked about and understanding the interplay of the two, and where there is discretion or subjectivity interpreting those. We are going to have to cite to cases, and what we'll see in the very cases is we'll either have someone suing the FDA or the FDA suing, and maybe something like injunctive relief where a facility is under a consent decree to stop operations. And we'll go through the various citations as we go through. Typically, when we're talking about the courts, there's a hierarchy of courts, and from the Supreme Court down to the district court, but we'll get into that when we get into the various opinions. Guidance documents is the tricky one. It's not a regulation, it's not a statute, obviously not the Constitution or a case law. It is the lowest threshold, the lowest rung of the ladder of authority. So when we talk about guidance documents, it's either when we have nothing else on the topic, or it's the most instructive on the topic because either the CFR is vague or the CFR isn't there, the Code of Federal Regulations. It is non-binding recommendations or thinking. It's truly what it means. It's guidance, but not authoritative. And we have draft guidance that comes out, and then it's finalized into final guidance. So if we even want to continue the hierarchy, it would be draft guidance at the very, very bottom and final guidance just above that. So my point here is when we talk about the legal system and you're doing an analysis, I don't want to see a written analysis that puts a guidance document over a statute. That's not how the system works. The statute would control over the guidance document because it is of a higher authority. So we kind of work our way down from the Constitution to the statute to the regulation to the guidance, maybe the type of guidance. To the side of that, we're going to have the cases that are interpreting or modifying each of those as we come across. As you know, coming from 6110, this question we tackled for 6 weeks. Are there other agencies involved in food regulation? For those that are just joining in 6110, here is a small list of some of the agencies that will come into play and could be involved at various stages of the regulatory life cycle. And for our purposes in 6130, we simply don't have time to get into each and every one of these. We're going to take the primary 2 food agencies, the USDA and the FDA, as our primary focus. There's lots to talk about just between those two. And where we can, we'll bring in some of these different pieces. We'll talk about DOJ, we'll talk about imports, a little bit about CDC. So we'll talk about these things a little bit, but they're really not going to be in depth. But I do want you to be aware that there is this other element of the food regulatory life cycle, of the food regulatory environment that we have. All right, so now we are in the final stretch, the overview of the FDA. And I know for many of you, because we've been talking for 6 weeks, and from my experience in other courses, you either work in industry or have people that do work in industry, you're familiar with the FDA, you're familiar with the USDA. And so I know we could spend a lot of time just skipping this, or we could just go into another topic. But I want to approach this in a way that is new. And I think what I'm trying to avoid is the knee-jerk type of analysis where we say, oh, that's a banana, that's the FDA. Oh, that looks like beef, that's the USDA. Generally speaking, yes, that is how the distinction between the two agencies' authority is seen. But what I want to make sure we're doing when we get into this lecture and we get into this analysis is, why is that banana FDA regulated, and why isn't it regulated by the USDA? And how do we define these terms, and are there different ways to look at that banana? And there are. We can put labeling claims on that banana that would maybe change how we look at that. And so I really want us to just kind of come into this topic, and the same with next week when we get into the USDA, with as open of a mind as possible, with as few preconceived notions as possible, and take this information in new and make sure that we're approaching those written assignments from that new perspective. So the FDA regulates food, and in general, like I talked about, the main distinction is food versus meat. And we have these different statutes that do that. And what we have in the reading this week is looking at the statutory section 201F. If we're talking about dietary supplements, 201FF, food additives we can add in there. And what we're trying to say is, what is food and how do we define that food? And we're looking at the NutriLab case. And I think what's important to remember is we're not only looking at this to say, what is food, so we can determine whether we're FDA regulated under this voluntary sporadic model versus USDA regulated in this compulsory mandatory continuous model, but even further than that, looking to say within the FDA, what center are we regulated by? Are we regulated by the Center for Food Safety and Applied Nutrition, regulated by Center for Veterinary Medicine, regulated by Center for Drug Evaluation and Research, something else, CBER, Center for Biological Evaluation and Research? And it's not far-fetched to do that. I've had a client with a peanut product that made certain claims and it brought it into CBER, and we had to have this jurisdictional tussle back and forth to see whether this peanut product could make claims that maybe were health claims that could also be CBER claims. So this definition matters for a number of reasons, and that's why I want us to stop and do this analysis and not just look at it and say, that looks like, in the case of the NutriLab case, this looked like a bean product or a starch blocker or whatever we want to call it. We want to look at that definition. We want to look at how the courts have said to look at that definition, this intended use concept that's so important to our course this next 6 weeks, and make sure that we're applying that definition and understanding that FDA jurisdiction. So there is this pretty broad jurisdiction that the FDA has of food, and it's kind of confusing because where does it conflict with the USDA's authority? And we can talk a lot about the history of why we have two food agencies. I like to rail against this topic because I think it's very frustrating that we have two food agencies. You look at comparative regulatory models and there are not two food agencies, there is a single one. And it's very frustrating because of the two very different compliance models that they have. I've alluded to that a little bit. Continuous, compulsory, mandatory is sort of the buzzwords for USDA FSIS inspections versus the voluntary, sporadic, sort of chase the problem approach that the FDA has. And there's a lot of history on why that happened, and it's interesting from a historical perspective to see how the passage of these two acts it drifted into being eventually two agencies. And again, we can look at this at a simple approach, and I think this is what we can do to help us get a grip with the concept if we're new to the topic: meat versus poultry versus non-poultry, non-egg products, and start there. But again, the real goal is to get into this intended use concept, the 201F or 201FF concept, if we're working with dietary supplements, and work from that definitional aspect. There are going to be some places where overlap, and we may want to note that. We may have facilities that are dual jurisdiction facility. Eggs is probably the one example where we can get into the most confusion about, is it USDA, is it FDA? We can also get into examples with mixed meat products or dual facilities, like I mentioned, where we make a vegetarian item and we make a meat item as well. We can get into some really strange examples like catfish, and it used to be one but then became this political football and is now another. And that points to something that underpins our law, is that there is politics and policy behind what we do. And so a lot of times we're looking at this and we're trying to find a food science rationale. Why would catfish be better suited in one agency versus the other? Was the switch on catfish based on scientific policy or scientific evidence? Why do we have two food agencies? Was the FDA better at other foods versus the USDA with these? And we can get into a policy politics argument. But, at a broad level, we just need to recognize that when we look at a product, we need to go back to the definitions, we need to go back to the intended use concept in some cases, and really understand where that jurisdiction comes from. So for many of you, you know exactly how to answer this question, how the FDA works. The FDA is based in what used to be a district-based model. Here in May, we're moving away from the Office of Regulatory Affairs into a different model. There is the civil criminal. We're going to talk a little bit about the criminal division. Majority of what we talk about will be civil. We're talking about facility inspections. We're talking about recalls. We're talking about import activities. All of those things are very familiar, and we'll get into the differences between the two models, in particular next week when we talk about the USDA. For the most part, we're talking about the Food, Drug, and Cosmetic Act. It's been amended at various points, but we still call it the Food, Drug, and Cosmetic Act. We'll talk about the Code of Federal Regulations. We've already this week got into some judicial opinions, and we will also get into guidance documents. So each of these are places where the FDA gets its authority. And again, think of it in terms of hierarchy when we're talking about which is more important or more authoritative than another piece of information. And I think this is an important point to make as we talk about getting into the nuance of what is food and getting into the nuance of FDA jurisdiction and getting into the frustration of why does the FDA have this particular model versus another model. And consumers spend a lot on FDA-regulated products. If you have an animal, you probably meet more than 75 cents of every dollar. You're maybe right at $1. Because think about it, you have your pet products, you have your cosmetics, you have your medical devices, you have your everything from OTC to prescription drugs, you have your food, your supplements. You can nearly touch something everywhere you go that is FDA-regulated in some form. And as we talked about in 6110, this underpins the model of economic trust that is so crucial to our economy. We, as consumers, must trust the industrialized food that we eat or other products that we have. And it's a real important part that the FDA plays. And that is why this course is important and this topic is important, and why these issues can be something to really wrangle with. So with that, we're going to close. It's been a longer lecture than normal. Next week will not be this long, and we will go into week 2 with our overview of the USDA. And again, all the slides are going to be in PDF format. So if you want to come back and look at the expectations in particular, those will be available in a PDF, and you can look at that and bring that into your week 1 discussion this week. Alrighty, take care.